Meet Sean. The year is 1998. Sean is a young programmer full of ideas. He also loves music. Sean wants to combine his passions by building a platform where he can share music with his friends and other people all over the world. He has a grand vision for his idea. If his service, which he is thinking about calling Napster, picks up steam, it could upturn the entire music industry. Of course, Sean wants to protect his project from other people who might want to copy or steal it. Sean's creation is protected by something called intellectual property. Intellectual property, also known as IP, is any innovation, commercial or artistic, or any unique name, symbol, logo, or design used commercially. Basically, IP protects the innovations of the human mind. Intellectual property rights protect the interests of those innovators by giving them property rights attached to those ideas. The term intellectual property rights stands for these legal rights that authors, inventors, and other creators have. However, at this stage, Napster is just an idea. Does Sean have exclusive rights to this idea? The short answer is no. Intellectual property laws relate to a particular way in which ideas or information is expressed or displayed, but not the actual ideas or exact concept itself. If another programmer on the other side of the planet came up with the exact same idea for a music sharing platform and built it first, Sean has no legal claims to ownership of that platform. With this in mind, Sean gets to work. Many months go by, and Sean has finally achieved his vision. Now that Sean has actual code, numerous forms of IP are available to protect his product. The first form is copyright. The 5 major rights granted to the creator are the right to reproduce the work, adapt or derive other works from it, distribute copies, display the work publicly, or perform it publicly. Copyrights last the span of the author's life plus 70 years. The fair use rule allows copyrighted works to be used without permission in non-profit settings, such as education. Software was not always copyrightable. In 1974, the Commission on New Technological Uses of Copyrighted Works was formed and came to the conclusion that computer programs, to the extent that they embody an author's original creation, are proper subject matter of copyright. In 1998, the Digital Millennium Copyright Act expanded on the matter of software protection by criminalizing the evasion and destruction of copy protection. Another form of intellectual property is the patent. Patents are the strongest form of intellectual property protection. Patents are awarded to inventions and discoveries of new and useful processes. Patent law protects not only the implementation of an idea, but the idea itself. Patents last for 20 years. To be awarded the patent, the invention or discovery must meet 3 key criteria. It must be useful, novel, and non-obvious. If Sean came up with the concept of peer-to-peer networking, he would have been able to apply for a patent on his technology. Yet another form of intellectual property is trademarking. Trademarks signify that a product or service comes from a unique source and distinguishes that product or service from similar entities. A trademark is typically a name, logo, phrase, or combination therefore of. It can even extend into other senses such as sound and smell, as long as it signifies a unique entity. Trademarks develop differently than copyrights. They generally develop over a period of time as the product gains public recognition. Also, unlike copyright or patents, trademarks can be used indefinitely. Napster is a runaway success. Millions of people are using Sean's services. He has sufficient copyrights and trademarks and isn't worried about other people stealing his idea anymore. However, Sean now faces the other side of intellectual property troubles. By freely sharing his music, Napster users are violating the intellectual property of artists and record labels. Artists such as Metallica, Dr. Dre, and Madonna are furious at the widespread copyright infringement of their music. Napster's legal issues came to head in July 2001. The RIAA successfully sues Napster, citing the Digital Millennium Copyright Act, and Napster is forced to shut down. Intellectual property in software is an ongoing debate. Commercial software and hardware companies depend on copyright protection to maintain an advantage and turn a profit. A few weeks ago, Apple sued Samsung for copying the likeness of the iPhone and iPad with their Galaxy S 4G model. Commercial companies face strong, vocal opposition. Advocates such as Richard Stallman and his Free Software Foundation believe that no one should hold copyrights on software. As a result, numerous alternatives to copyright, collectively known as copyleft, have sprung up. The most popular example of copyleft is the GNU General Public License. Regardless of one's personal position, intellectual property plays an important role in society and will continue to do so for a long time.